So we have now discussed in great detail what are the obligations under the GATT, what are the basic obligations WTO members necessarily have to comply with in the field of trade and goods. And we did mention partly services trade, intellectual property regulation. And until now, we still never understood what is the process of any responsibility for the violation of those rules, what are the rules on this responsibility, how it is done, is there any dispute settlement mechanism, and how it works. We mentioned the dispute settlement mechanism in one of our earlier lectures when we talked of decision-making process, and you remember we said it was a big breakthrough as compared to the GATT old system, that the new dispute settlement mechanism was made compulsory. There is no way to have it blocked by the losing party. For one simple reason, there is this reversed consensus rule, which is used when we talk of the adoption of appellate body reports and panel reports. And we said that it is next to impossible under the current terms to reach this reverse negative consensus. So that is it actually. As for what we have said so far, you understand that there are two stages of dispute settlement, panels and appellate bodies. And I think we said that ultimately all their decisions go to be approved, adopted by the dispute settlement body, which comprises of the members of the WTO. And as we said, no WTO member is excluded from the system. WTO is a driver, is it's a member-driven organization, so all decisions would be taken purely and solely by the members. So the goal of this last lecture is just to understand what are the consequences of the violation, how disputes are solved, and what are the results of those disputes, how is compliance working. So to begin with, we need to understand, first of all, what are the matters that could become subject matter of the dispute before the WTO dispute settlement body. And in that sense, Article 23 of the GATT will be very helpful because it gives us the list of the so-called admissible complaints. International courts are not courts of general jurisdiction. They are not taking all the possible complaints that could come up with, that the parties could come up with, and they are very limited in the field of their jurisdiction, in the field of their applicable law. They cannot consider any complaints unless parties have specifically commissioned them to consider those cases, have specifically vested powers to consider cases to the dispute settlement body. And the provision that explains the admissible complaints with respect to the dispute settlement body is here in Article 23 of the GATT. Article 23 of the GATT is called Nullification and Impairment. And it says that the GATT contracting parties can initiate a formal dispute. Here it is worded as make written representations or proposals to the other contracting party. And if they are unable to reach any agreement, then the matter may be referred to the contracting parties in capital letters. So that is exactly what is prescribing the dispute settlement that we now know under the WTO rules, well, and that was there before under the GATT. So if there are certain concerns on some nullification or impairment, which we will talk about, then the GATT contracting party may make written representations, something like a complaint, something like a request for consultations, and if there is no result of those consultations, then the matter may be referred within a reasonable period of time. Then the matter may be referred to the contracting parties. How do we understand this term contracting parties in capital letters? You might have noticed that throughout the text of the GATT, sometimes you would see these capitalized contracting parties, and it is explained in Article 25.1. It says, wherever reference is made to, in this agreement to the contracting parties acting jointly, they are designated as the contracting parties in capital letters. So whenever we say that the matter will be referred to the contracting parties, it means that if the two WTO members, if the two GATT contracting parties are unable to resolve their dispute, then this dispute can be referred for the final resolution to all WTO members acting jointly, to all contracting parties. So that is exactly what is institutionally framing that mechanism known to us when a dispute is first at least potentially could be resolved through consultations, and then if the parties do not agree, then a formal dispute can be sent to the dispute settlement body. That's what we would now call the contracting parties in capital. That is dispute settlement body actually, and the dispute settlement body acting under its rules will take all the necessary steps so that to resolve the dispute. So what could be the ground for these written representations or proposals? I'm a little structuring the provision differently. So if you're following Article 23 in your own text, you will see it a little differently, but it doesn't make a big difference in sense of substance. So when could such written representations or proposals happen? They could only happen if we have a situation of a nullification or impairment. That's the title of Article 23. So what is nullification and impairment? Well, we do understand the words nullify or impair. Nullification meaning that it goes to zero, completely evaporates, something doesn't exist any longer. Impairment is likely to mean not complete nullification, not total disappointment of the complete even disappearance of a benefit, but then just some restriction of the benefit, impairment of the benefit. So the English names are pretty straightforward. So if any contracting party should consider that any benefit accruing to it directly or indirectly under this agreement is being nullified or impaired, or that the attainment of any objective of the agreement is being impeded as a result of something, then this contracting party can make written representations and then start a formal dispute. So that is how the article is framed. So this is a very classical and understandable approach that is known to all of us. In all legal systems internationally, disputes are not initiated just for sake of interest, idle interest. In order to initiate a dispute, a party needs to demonstrate that some of its rights have been infringed, or maybe its legitimate expectations have not been somehow respected. So in any case, there is a need to demonstrate your own involvement in the situation. So no courts, well, next to no courts, accept disputes just by the parties unrelated to the problem. Well, sometimes prosecutors may act on behalf of someone's interests in national systems, but actually internationally we don't have any widespread practice of even any prosecution, anyone acting in the interests of the government. Well, it can sometimes happen with obligations erga omnes, so-called, against all obligations with respect to the whole international community, when we do not check the standing, as we call it, whether the complaining party has the right to bring the dispute. But here we see that Article 23 gives us a straightforward obligation for the complaining party, for the contracting party that wishes to initiate a dispute, to necessarily demonstrate that benefits that accrued to it directly or indirectly under the GATT were nullified or impaired. Alternatively, the reason for the formal complaint could be the attainment of the objective of the agreement, of any objective of the GATT. I could not tell you much. We did not have a lot of jurisprudence in that sense interpreting this provision, and it is more unlikely to happen like that, because still usually any dispute would mainly have the specific interest of the other WTO member involved, who would wish to protect its right, or at least its expectations that it considers legitimate, to have those protected from the acts of the other WTO members. So we can initiate a dispute if we demonstrate nullification and impairment of the benefit that is accruing to a WTO member under the GATT or in case we could demonstrate the attainment of any objective of the GATT. However, this nullification and impairment, or the attainment of the objective, according to the provisions of Article 23, could take three forms. So, benefit is nullified or impaired, or objective of the agreement is impeded as a result of the failure of another contracting party to carry out its obligations. This is simple. So if any other WTO member is violating the rules, then we can clearly show that as a result of that, our benefits have been nullified and impaired, and we can make written representations, we can initiate a formal dispute. But that is not the whole provision. Interestingly, there are other grounds when WTO members could initiate disputes. And the most tricky one is the next one: the application by another contracting party of any measure, whether or not it conflicts with the provision of this agreement. So, the application of a measure which is not necessarily in conflict with the provisions of this agreement. This is impressive. So we do not permit disputes that talk of nullification and impairment as a result of WTO violations, but we also permit disputes about nullification and impairment of benefits when there is no violation of the WTO rules present. And this is interesting because this type of complaints is clearly not typical. And then, to make situation even worse, let's read 23(1)(c), the existence of any other situation. So, having read that, we understand that any nullification or impairment of the benefit that is accruing directly and indirectly to WTO members under the agreement can be challenged to the WTO dispute settlement body, can be subject to a formal complaint. And it does not necessarily mean that it could only happen in case of violation of rules. Non-violation complaints could also happen, as well as the so-called situational complaints. So if I were to transform it into the more simple terms, those are violation complaints, the most classical, straightforward, and understandable. Non-violation complaints when there is no violation on behalf of the responding party, but still as a result of their action. And notice that again, it should be the application of the other contracting party. So it still has to be something attributable to the other contracting party. It should be state behavior of any measure, whether or not it conflicts the provisions. And C, situational complaints. So those complaints which are violation complaints are straightforward and classic. We understand that it's a violation of, say, MFN, national treatment, it's the imposition of an import restriction or a quota, whatever. Non-violation complaints, when can they happen? And this is quite simple if you recall the examples we were giving in our lectures. For instance, you may recall that under Article 3.8, subsidies could be provided to domestic producers in case they are provided in the form of some expenditure on the side of the government, and if they are provided directly. So subsidies of this type are permitted, but still, if the subsidies result in the nullification and impairment of the benefit, they could be subject to a non-violation complaint. So if subsidies are provided in such amounts that they really nullify or impair the benefit of other members under the GATT, then it could be a ground for a formal complaint. What is the situation? Well, the other example of a non-violation complaint is my example with the Russian president saying in each and every interview that foreign cars are bad and Russian cars are very good. We said that it is not a violation of Article 3.4 for a simple reason that it is not a law, regulation, or requirement. Therefore, whenever we try to approach this problem from the formal Article 3.4 perspective, we are unable to establish a violation. However, it can be a non-violation complaint in case we demonstrate that indeed, as a result of this action, benefits that were accruing to other WTO members have been nullified or impaired. And the situational complaint is something we never actually saw in practice. And the situational complaints they permit challenging not even the behavior of other WTO members, but the existence of any other situation. If you recall the phrase how it was there in Article 23C, 23(1)(c), and what is it? It's a big question. Potentially, maybe it could be anything, but we did not yet see any examples of situational complaints filed to the WTO. So when we say benefit being nullified and impaired, the core question, therefore, to start a dispute is not to demonstrate the violation of the WTO rules, but to show that benefits have been nullified or impaired. What sort of benefits are we talking here? How do we understand these benefits nullified or impaired? The panel in one of the actually non-violation complaints, Japan Film, tried to explain what sort of benefits are meant. And clearly, one of the examples are those benefits which were legitimately expected by a member from successive round of tariff negotiations, reasonable expectations of improved market access. So when acceding to the WTO, when negotiating tariff schedules, you have a certain expectations on the level of market access that your products will be able to obtain in a foreign market. However, if as a result of the application of a violation of WTO rules or of a non-violative measure, your access to this foreign market is nullified or impaired, then it can very well qualify for the requirements of Article 23.1. So when we say, what are the benefits? Well, one of the most classical examples of the benefits would be these legitimate expectations of market access, which have been promised to WTO members by other WTO members. And then how do we demonstrate that our benefits have been nullified or impaired? It will be actually the analysis, again, of the same competitive positions. It must be demonstrated that the competitive position of the imported product, subject to and benefiting from relevant market access tariff concessions, is being upset by the application of a measure not reasonably anticipated. So we would need to make some economic studies to demonstrate that as a result of this measure, our ability to enter that market has significantly decreased as compared to what was promised under the schedules and under the other obligations as part of the WTO single undertaken package. Yes. So that is the most important, getting back to nullification and impairment of the benefit, that you need to keep in mind that in order to initiate a dispute, this nullification and impairment of the benefit will have to be demonstrated. That is the minimum requirement to start the dispute. And then in 1995, with the formation of the WTO and with the new agreement on the procedural aspects of dispute settlement coming to existence, the dispute settlement understanding, there has been a change in the approach towards violation complaints and nullification and impairment. It only applies to violation complaints, and no changes are there for non-violation complaints and situational complaints. But this change with respect to violation complaints significantly simplified the standing, simplified the abilities of WTO members to initiate formal disputes. So what was the change? The change is there in DSU Article 3.8. It says that in cases where there is an infringement of obligations assumed under a covered agreement, so when we talk of a violation complaint, the action is considered prima facie to constitute a case nullification or impairment. This means that there is normally a presumption that a breach of the rules has an adverse impact on the members' parties to that covered agreement, and in such cases, it shall be up to the member against whom the complaint has been brought to rebut the charge. So here they say that there is a presumption that any violation complaint has nullification and impairment component already in it. And one of the classical phrases of the appellate body in EC Bananas is that all WTO members have systemic interest, so there is no need to demonstrate the nullification and impairment of individual members when we talk of violation complaints. And still this presumption is rebuttable. So potentially WTO members could say that the complainant has absolutely no interest in trading in this product. For instance, it is not trading with me currently, and therefore I don't understand why they initiate a dispute. And potentially those presumptions could be rebutted, but so far we did not see a single case when this charge was rebutted. So all claims have been accepted, and it has been always considered by the appellate body and the panel that the complaining member does have interest, at least systemic interest. So I don't know yet if it is possible to imagine a situation when such absolutely unrelated party would be not permitted to initiate a WTO dispute. So there is a presumption that benefits are nullified and impaired if we talk of violation complaint. There is a presumption of harm, if you wish to put it in more simple, not exactly correct, but maybe more straightforward terms that could help understand the approach. This results in extremely strange situations, like the case which I already mentioned called Australia plain packaging. You may once again see the example of this plain packaging regulation that to the sides you may see the usual packaging of cigarettes, and in the center you would see the packaging of cigarettes as it currently stands in Australia. You see that two separate brands look absolutely identical, with the only difference being the identification of a brand in the same font, without any pictures, without any other ways of attracting attention, without colors. Who were the two parties first initiating a dispute against Australia in this case? Well, we understand that the most unhappy parties with this regulation are big tobacco companies. You know British American Tobacco, you may know Japan Tobacco, you know Philip Morris. Philip Morris officially has its headquarters in Lausanne in Switzerland, so it is sort of a Swiss company. On the other hand, they claim to be a US company as well for other reasons. British American Tobacco is a company that is domiciled in the EU, and Japan Tobacco, from its name, you understand, its headquarters are located in Japan. So in order to initiate a WTO dispute against this Australian plain packaging legislation, which resulted in tremendous harm for their market and all the marketing investment that they have made, it is now all in vain. So in order to challenge it, those companies need to find a government that would initiate a dispute in their interest under the rules of diplomatic protection. So companies themselves do not have access to WTO dispute settlement. WTO dispute settlement is only available, as we saw, to contracting parties. So governments need necessarily to jump in. So these cigarette majors go to Japan, to the government of Japan, go to the government of the United States, go to the government of Switzerland, they go to the European Commission, and they ask for support. However, in all of those countries, the response is, we are sorry, we do not wish to initiate a dispute, formal dispute against a non-smoking legislation, because ultimately, at least officially, we ourselves claim to be against smoking. Yes, we are very grateful for your taxes. We are very thankful that you are still with us, but this time we would not be able reputationally to go and initiate a dispute. And if it was the general Article 23 rule of 23 of the GATT rule, then the dispute wouldn't go any further. However, as you saw under Article 3.8 DSU, any WTO member can initiate a dispute when we talk of a violation. So these major producers of cigarettes all over the world start visiting various governments and start convincing them initiate a dispute in their interest. Again, we don't know what do these governments get in return, but clearly it is not a matter of just pure, pure challenge of the foreign legislation they are not interested in. So there should be some financial interest behind it, or maybe not necessarily financial. Maybe these companies promise that they will, I don't know, build a road or build a plant or I don't know, somehow build a new factory and employ X number of people. I don't know. But they did manage to find two governments which actually initiated this dispute against Australia. Interestingly, those were not actually trading cigarettes with Australia, and the two governments were the Honduras and Ukraine. And we don't really know how did they manage to convince those governments, but the formal disputes were launched. Then other countries joined, Dominican Republic that also has already the production of cigarettes, which is impressive and which is being sent to Australia. But in the long run, the first two governments were Honduras and Ukraine. Interestingly, in 2014, following the change of the government in Ukraine, the new government came to power, the new people came to take care of trade policy, and there was an announcement, a pretty interesting one, on the website of the Ministry of Economics of Ukraine, saying that the Ministry of Economics has analyzed those disputes that were initiated by Ukraine in the WTO. They found out that there is a dispute against Australia. There is no clarity as to which particular Ukrainian company may be interested in that. And clearly there has not been a single cigarette ever sent from Ukraine to Australia. So as long as we did not manage to identify those countries, those parties which are interested, we are now puzzled as to what to do with this dispute. Therefore, if there is anyone interested in continuation of this dispute, please come to us for negotiations. What means, well, those guys that you negotiated with, those guys that took your envelope, ran away, we now don't know who you are and why we should act in your interests. So if you want us to act in your interest, come now and negotiate the terms of the support from us with the new team. Clearly, well, already our cigarette giants gave up. They said, well, we have already made arrangements with the previous guys. So, but luckily there was also Honduras and other countries that initiated the dispute. So the dispute was finally heard by the WTO. It was not a successful one, but still it was heard by the WTO, though Ukraine dropped the claim, and the claims by Ukraine were not therefore part of the final findings. So then there is one more thing that is important before we discuss the dispute settlement process that is important to understand. It is the jurisdiction of the dispute settlement body. And the jurisdiction of the dispute settlement body is something that we really need to take very seriously, because every international tribunal has very limited jurisdiction. They can only hear cases that fall within the ambit of what they can do. In public law, actors can only do those things which they are authorized to do, unlike in private law, there you can do anything that is not prohibited. So in public law, jurisdiction is fundamental, because unless the tribunal has the jurisdiction, the tribunal cannot hear the case. So the jurisdiction of the dispute settlement body with respect to WTO dispute is on the one hand compulsory. It straightforwardly says that when members seek to redress a violation of an obligations or other nullifications or impairments of benefits under the covered agreements, they shall have recourse only to the WTO dispute settlement. You could not go to any other international tribunal to seek any determination on the violation or non-violation of WTO rules. The jurisdiction of the DSB is compulsory, and therefore no other international tribunals could have WTO rules, WTO violations as part of their jurisdiction. And then it is also exclusive. That is exactly what I'm saying. In such cases, members shall not make determination to the effect that a violation has occurred except through recourse to dispute settlement in accordance with the rules and procedures of this understanding. So in cases there is a violation, you cannot act unilaterally, you cannot introduce any sanctions, counter sanctions, whatever. You are obliged to go to the WTO dispute settlement body. If you think someone is violating WTO rules, the other member is violating the WTO rules, you cannot use any other mechanisms but for DSB mechanisms. And this is why in the lecture on security exceptions, I said that, yes, United States violates the rules on, say, the imposition of the section 232 measures, aluminium and steel safeguards, aluminium and steel tariffs. But importantly here, those countries which in return introduced also additional tariffs against the US products and clearly violating WTO rules are not only violating the rules on tariffs, they're also violating the rules of the DSU, because the violation can only be combated through the dispute settlement mechanism, and there is only dispute settlement body all over the world that is able to hear cases with respect to WTO violations. No recourse to other international tribunals on WTO matters is possible. We have already seen many times that here and there, the reference is made to the covered agreements. If we just go back to Article 23 and 1, it says again, members seek the redress of a violation of obligations or other nullification or impairment of the benefits under the covered agreements. This term covered agreements is the cornerstone of the concept of the jurisdiction of dispute settlement tribunals within the WTO. The scope of jurisdiction as determined in Article 1.1 says that the rules and procedures of this understanding shall apply to disputes brought pursuant to the consultation and dispute settlement provisions under the agreements listed in Appendix 1 to this understanding, referred to in this understanding as the covered agreements. So now we understand what the covered agreements are. The covered agreements are those agreements which are listed in Appendix 1, and with respect to these agreements only, the dispute settlement body will have jurisdiction to hear cases on violations, non-violations, situations, whatever. What is there in this Appendix 1? If you see the Appendix 1 list, you will be puzzled how much it reflects the structure of the WTO agreements. So it's, on the one hand, the Marrakesh Agreement itself, then the multilateral trade agreements on goods and services, on intellectual property, and the DSU itself. So that is it. With respect to plurilateral agreements, DSU does apply partly only in cases where a reference to DSU has been specifically made within those agreements, and therefore there should be a specific provision in those agreements to bring cases under the DSU. It is not all of those that actually have this provision. Say the agreement on trade and civil aircraft does not have reference to the DSU provisions. So then just the old GATT procedures under Article 23 would apply. DSU will no longer be there. So the jurisdiction is limited by the covered agreements, and even the capacities of the WTO dispute settlement mechanism are limited with respect to the covered agreements. The dispute settlement system of the WTO, it says, is a central element in securing stability, predictability of the international trading system, and it serves to preserve the rights and obligations of members under the covered agreements and to clarify the existing provisions of those agreements in accordance with customary rules of interpretation of public international law. And here, importantly, what they say is recommendations and rulings of the DSB cannot add or diminish the rights and obligations provided in the covered agreements. So ultimately, what the DSB can do is only hear cases with respect to covered agreements, on the violation of covered agreements, other forms of nullification, impairment of the benefit under the covered agreements, and they can only apply covered agreements to make any findings. So they cannot go beyond these restrictions, because this is something that in public law has to be interpreted narrowly. There is a beautiful example of a dispute between two brilliant lawyers with respect to the jurisdiction of the dispute settlement body. Just Pauline on the one side, and Gabriel Marceau and Anastasia Stamazis with comments on the paper by Pauline called How to Win a WTO Dispute Based on Non-WTO Law. Both papers are available on Google, online, you can find it, no problem. And that is a brilliant example of a dispute with argumentation when you feel convinced by the passion of both sides. And I highly invite you to read it, because it is one of the beautiful examples of a proper scientific debate, as it should be. So there they discuss whether the dispute settlement body could not only apply WTO rules, covered agreements, whether they could also use some other international rules, other international agreements, because international agreements are huge in size and volume. International agreements are omnipresent. And then if we, as if completely disregard the existence of other agreements, then WTO law would be isolated from the family of public international law. And in US Gasoline, the appellate body emphasized that WTO law shall not be read in clinical isolation from public international law, but the question is whether we could refer to other agreements outside the scope of the World Trade Organization agreement set of the so-called single undertaking in order to initiate a dispute. And here the discussion again is how far could we go with other non-WTO rules to be applied. Imagine, for instance, a situation which was actually not that far from reality, that the two WTO members agree in a bilateral agreement not to initiate dispute with respect to a trade measure, and then one of them, contrary to this agreement, which is bilateral and which is in force, and you know that the general principle is pacta sunt servanda, so all agreements shall be complied with, and parties shall abide by the terms of the agreements. So what happens if they agree not to challenge a WTO measure, and then one of them still goes and not to challenge a trade measure, and one of them still goes and challenges it and brings a complaint, formal complaint against it? Could it be something that would be to any extent prohibited by the WTO rules? And that is a difficult question, because seemingly the WTO rules do not permit taking into account this type of an agreement, as long as it could influence the scope of WTO obligations of the members. So recommendations ruling cannot diminish or add rights and obligations provided in the covered agreements. Could, say, WTO dispute settlement body just reject jurisdiction, say, we could not hear this case because you promised not to bring a case before us? No, they cannot. just because, well, seemingly from the provision that we are reading, they can only apply covered agreements, and this bilateral agreement between two members is not a covered agreement. The list of the covered agreements is there, it is exhaustive, we saw it, and no bilateral agreements were there. So here there is some reference to customary rules of interpretation of public international law that could help us make WTO law meet international law. But seemingly, at first glance, we have a feeling that WTO rules are not very much in favor of interpreting, not in favor, well, the WTO rules are rather rigid, and the jurisdiction of the dispute settlement body is not likely to include any other norms of international law but WTO agreements only. And therefore, it's a dispute between DSB jurisdiction and the applicable law. The question that is mostly debated by Pauline and Gabriel Marceau is with respect to the understanding of these terms, where we understand that jurisdiction is limited to covered agreements, but what Pauline proposes is that applicable law could be broader and could include other international agreements, or at least we understand that the situation when international law is so fragmented and international agreements are not taken into account by WTO dispute settlement body because of the exclusive jurisdiction of the WTO dispute settlement body, the findings of the WTO dispute settlement body shall not influence the other provisions of international law. This is not a good situation, and therefore Poland tries to develop some theory that would make the two things meet. He says that maybe applicable law is much broader than the covered agreements, and the applicable law shall include other rules of international law in force between the parties to the dispute. Alternatively, we could say that maybe international law is only part of the interpretation exercise under Article 31 of the Vienna Convention. And again, it's for lawyers, it's a legal story, but it is understandable that within Article 31 of the Vienna Convention, it says that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms used in their context and in the light of its object and purpose of the treaty. And they say that together with context, any relevant rules of international law applicable in relations between the parties to the agreement that is now being interpreted shall be taken into account. So we do understand that those rules of customary international law on the interpretation from the Vienna Convention would permit us keep in mind this agreement, and actually it would not even permit to take into account this bilateral agreement because it's not an agreement applicable in relations between the parties to the GATT. It's only two parties to the GATT being parties to the agreement. Here we will be able to apply for the interpretation of WTO rules those public international rules which are binding for all other WTO members. But even putting that aside, we understand that yes, clearly for the interpretation we could use other rules of international law for the interpretation of the GATT, but we cannot, seemingly we cannot apply other agreements, and we cannot make findings based on other agreements before the WTO dispute settlement body. So irrespective of how good your agreement is, you cannot refer to a bilateral treaty between EU and South Korea before the WTO dispute settlement body because it is not part of the covered agreements, and it is not even really relevant for the interpretation in the sense that it is not an agreement that is as amongst all WTO members. And this finding is supported by jurisprudence. The case is called EC Poultry. The question there was that Brazil claimed that EC had not provided it with the full allocation of the tariff rate quota of frozen chicken imports, contrary to their bilateral oilseeds agreement. There was a big dispute on the EEC oilseeds. I think we even mentioned this dispute before. And under the dispute, there was an arrangement reached that was a bilateral agreement how to settle this issue. And this oilseed agreement was violated, and the question was whether this oilseed agreement could be applied by the WTO dispute settlement body. It's a legal agreement, it is in force, it is binding for both countries, but as long as the jurisdiction of the dispute settlement body is limited, here what the appellate body says: the oilseeds agreement is a bilateral agreement, it's a part of the resolution of the dispute in EEC oilseeds. As such, the oilseeds agreement is not a covered agreement within the meaning of Article 1 and 2 of the DSU, nor is the oilseeds agreement part of the multilateral obligations accepted under the WTO agreement. The oilseeds agreement is not cited anywhere among the covered agreements, so we could not apply the oilseeds agreements. It may be useful for the interpretation, and again, because of the restrictions in Article 31(3)(c), how we determine parties, even for the purposes of interpretation, the applicability of this bilateral agreement will be very limited. Is it a good, is it a positive sign? I don't know, I doubt. We here seem to be in favor of this fragmentation of international law, isolation of WTO system from the rest of the body of the international public international law, but that is where we are. The jurisdiction is very limited, applicable law seems to also be limited, and therefore, when we want to go and resolve a WTO related dispute, we can only go to the DSB, we cannot go elsewhere, but we could not expect the DSB to apply any other rules but for the covered agreements, and that is it. These are the restrictions we should be mindful of. So the dispute settlement process now, how does dispute settlement happen, and what are the stages, what are the terms, how long does it take? So whenever a formal dispute has to be initiated, usually there would be negotiations held before it unofficially, but sometimes it is not necessary. So the first formal step is request for consultations that a WTO member sends to the other member, copying it to the WTO. And then negotiations should last for at least 60 days, and they may try find an amicable settlement of the matter. The measures could be reviewed, the measures could be changed, the measures could be amended or abolished completely. And it happens quite often. You may see in a number of cases on the WTO website that those remained in consultations. It means that parties managed to agree on those concerns that were raised, and any form of solution was developed. If it is not possible to reach an agreement following 60 days of consultations, parties can take more time if they wish, but 16 days is minimum. Then the next step would be already the most formal, already initiation of a dispute, which will be the request for the establishment of the panel. A request for the establishment of the panel is sent to the dispute settlement body. There is the clarification added that consultations remain fruitless, and therefore, please, we request the panel to be established for our concerns to be heard. The establishment of the panel is done no later than on the second meeting from the moment when the issue was first raised. So the complaining party under the WTO, under the DSU rules, can block the decision on this matter during the first meeting, but in the second meeting, the panel shall be necessarily established. It gives some additional flexibility of, say, a month, because each month there is about one meeting on average of the dispute settlement body. So about 30, 50 days, depending on the schedule, maybe 60 days, depending on the schedule of the dispute settlement body, would be necessary in order to initiate, in order to have the panel established. But it will necessarily get established. and then the panel has to be composed. As you may remember, the panel usually consists of, well, the panels do consist necessarily, not usually, but necessarily consist of 3 members of the panel. And sometimes those would be a lawyer, an economist, a trade diplomat, but it is also not compulsory. And according to the DSU rules, those cannot be the nationals of the litigants, of the complaining party, of the respondent. Those could not be the nationals of the third parties, and everyone can join a dispute as a third party at the moment of the panel establishment. Whoever raises hand is permitted to participate as a third party in a dispute. Being a third party gives you certain advantages. You can get the materials, you can express your own concerns. It doesn't give you much of additional rights, but it does give you at least a good tool to keep track of what the dispute is actually about and what is the current status of it. So many countries like China and Russia participate in most disputes just to keep track of the developments. Well, same EU, US, just to keep track of what is going on and what are the arguments raised. If you have capacities, do it. It doesn't have any disadvantages. So nationals of those territories would not be permitted to be members of the panel. And therefore, most often the members of the panel would be from countries like Switzerland or Australia, New Zealand, those countries which are not that heavy users of dispute settlement system and do not participate that often as third parties. Because again, this nationality criterion is complicated. Parties can choose arbitrators, well, bad word, members of the panel, themselves if they manage to agree on the candidacies. It's very difficult for the parties to agree on the candidacies, and it always ends up with, well, very often ends up, not always, very often ends up with the dispute settlement with the Director General of the WTO appointing the panel. That is the only situation when the Director General of the WTO can jump in and somehow influence. It's the appointment of the panelists from the roster that the member, that the Director General has. What is important here is that it takes some time. It may take a month or two, but some of the candidates may be unavailable, so it will take longer. And even the composition of the panel may take several months. So at least 30 days is minimum. It may take longer because if parties do not agree, then the Director General jumps in, then appointment, understanding of schedules, trying to find all the candidates, their availability, and so on. Panels do not exist on permanent basis. Panels are called ad hoc, meaning that they are called to resolve a particular dispute. Before the dispute is there, no panel exists. So those candidates are very randomly selected there. They can be, they can have no experience of being judges or being members of the panel before. So still, usually those are professionals in the field of international trade, though they are greatly assisted by the Secretariat in drafting, in research analysis. They do a lot of work on their own as well, so that to analyze the materials, get prepared for the substantive meetings of the panel with the parties, and to deliver the final report. So what happens next is that panels start examining the case. And as I said, there would be substantive meetings. Usually there are 2 substantive meetings, one with the presence of the third parties, one without the presence of the third parties, where panels could raise questions, ask questions to the parties, clarify their positions. Sometimes panels may need to appoint expertise. They may request the positions of other international organizations, and it all takes longer time. The presence of many third parties can also complicate and extend the dispute settlement process in time. And well, according to the proper ideal schedule, panel examination should not be very lengthy, but it takes on average, I guess, no less than 9 months. There is a fast track procedure available for, as it is claimed, 3 months, but actually it is not really widely used. So the panel examination takes pretty much time, and you understand that the violation started even before consultations were initiated. So all these half year or even a year with a couple months more, the violation is still there. The measure which is originally challenged can still be not removed. So it is still a big disadvantage of the complainant. Then, once the report is prepared, it is reviewed, it is sent first to the parties. Parties check their positions to be correctly reflected. They already know who is the winner of the case and on which aspect. Sometimes they, despite the obligations of confidentiality, inform the press. There are leaks, and some of the panels even introduce special systems of minor differences in the text, which are sent to the parties. However, looking at the text, you could identify which is the party that is responsible for the disclosure of this confidential information, but what would you do if the information has already been disclosed? But it also takes some time, maybe a month or so, and then once the report is adopted by the panel, once the final text is verified by the panel, it is sent to the parties and to all other WTO members. It is called the circulation. And from the moment of circulation, there can be two options. The report can be either adopted or it could be sent for appeal. Officially, the report should be circulated no more than 9 months from the establishment of the panel, but in reality, it takes longer, quite often. So then the report could be adopted by the dispute settlement body. Again, it should be done within 60 days from the circulation, and parties there can sit and decide whether they wish to appeal or whether they do not wish to appeal. So imagine that we have the meeting of the dispute settlement body that is scheduled to adopt the report, but then at this meeting, the parties identify their willingness, or one party identifies its willingness to appeal. And the appellate review is also provided for by the dispute settlement understanding. It is not a binding stage. It's up to the parties to appeal or not. And we had a number of reports like, say, EC Biotech or EC commercial vessels that have not been appealed. But ultimately, many parties do go and appeal their report of the panel for various reasons. They may be unhappy with the findings. The appellate body is a body which is a standing body of 7 members. I think we mentioned the appointment and even mentioned the current crisis of the appellate body that is currently there in our previous lectures. The appellate body review is only, appellate review is only limited to questions of law. They are not considering the questions of fact. They are not making the analysis of all the evidence afresh. They are limited in their abilities just to correcting the violation, the errors panels could make in their findings. Therefore, sometimes the appellate body would say we do not have enough factual material to make findings, we cannot complete the analysis if the panel did not collect enough evidence or did not clarify certain important matters which would influence the findings of the appellate body. What would you do with that? Unfortunately, no, you cannot send it back to, according to the rules, you cannot send it back to the same panel to hear this case again. It's not how it works under the DSU. So the appellate review should take 90 days, but in reality it takes longer. The appellate body has been always overloaded with work, and clearly it is not possible to hear the cases at such high speeds. and the violation is still there. What happens next? Then the appellate body adopts the report, or well, not the appellate body sends the report for adoption. It circulates the report, then it sends it for adoption, and then it gets adopted again by the dispute settlement body within 30 days from the moment of circulation. The violation is still there. So how long is this mechanism already? 2 years, 1 year and a half, easily. So parties can even try to stretch that period. This is not a good faith tactics, but it could be in the interest of the government that does not wish to comply if it understands it's in violation. Then what happens next is that parties need to determine the period for compliance. The dispute settlement understanding does not give any specific time for the report to be complied with. Parties should agree on this compliance period, and it should be reasonable. Sometimes parties manage to agree on it, sometimes they are unable to agree on it, and then they will even appoint an arbitrator to determine the reasonable period of compliance, what will add additional 2-3 months on top of all the lengthy process we have already identified. So then a reasonable period for compliance is determined, and this reasonable period for compliance may not necessarily be a week or two, and it is next to never a week or two. Most of the measures that are brought to the WTO are laws, and they may require significant changes in the national legislation through the legislative process, and therefore it would require all those readings to be passed in the parliament and so on. So on the very average, the reasonable period for compliance when we talk of legislative measures, on average would be about a year or 15 months even, because it is a lot of work that has to be done in the country to change the rules. It cannot be done overnight very often. And if we talk of, say, European rules, or if we talk of the rules of the Eurasian Economic Union, when it is not just one nation responsible for those rules, but many, and there is a need to hold negotiations with all the other members. Therefore, it takes additional time to have decisions taken. So compliance periods can be very lengthy. It's a reasonable period of time. That is the phrase used in the DSU, but it doesn't give us the exact time frame, how long it should take. Then after these, say, 12 months of compliance, the period of compliance should expire without any steps taken. There can be situations when the complaining party believes that this compliance that is claimed by the respondent is not a real compliance. They believe that, yes, they changed the law, but it actually didn't change the substance, and the violation is still there. And then we would again have the appellate compliance panel, so-called, to check if the new measure does comply with the rules, if the violations have been eliminated, what is really also additional lengthy step that takes additional time. Let's say in the most optimal scenario, 30 days after if there is no compliance panel, 30 days after the end of the period for compliance, what the parties could do is finally retaliation. So we only arrive to this stage after all these steps, and it can easily take 2 years or even more. If the respondent wishes to drag it out longer, it can do it with all the procedural mechanisms available. Unfortunately, within the WTO, we don't have the system of retrospective retaliation. Retaliation doesn't work backwards. It only works for future violations. So you will not be compensated for the violation that happened through all these 2 years of dispute settlement. But the prices at stake are so substantial that governments are still ready to go through all these steps in order to get the permission to retaliate, or at least to stimulate compliance, despite all the costs incurred with this dispute settlement procedure and despite its lengthy nature, but still measures can stay in force longer. Violations can stay in force longer, not for a year or two, but for 3, 5, 10 years, and it will greatly disadvantage your domestic businesses. So clearly, some governments can act in bad faith. There is a classical example of George Bush during his second presidential campaign. He promised in some of the states during his campaign. He promised that if they support him, he will necessarily protect them from the European steel manufacturers, and he will introduce some protectionist mechanism. And indeed, once he got re-elected, he was a man of a word. So he indeed introduced a steel safeguard prohibiting the importation of steel to the territory of the EU. And effectively, the European steelmakers claimed that the costs they incurred because of this restriction amounted to around $2 billion a year. But interestingly, the United States was very happy to comply with the finding of the panel. They did not even appeal the measure. They said, yes, we are in violation. Okay, we will, clearly we are very compliant. We will comply immediately as soon as possible. Give us some time, but we will. The idea here is that from day one of the existence of the measure, they understood that there was no ground for this safeguard to be implemented at all, but it was implemented, and it gave some effective protection for about 1.5 years, maybe even longer, maybe 2 years, and then got removed. So is it bad? Yes, it is bad faith, but this is using the disadvantages of the system, because should there be retroactive sanctions for the violations, clearly George Bush would not do that. But as long as retaliation only starts from this red rectangular and further on, if the violation is still not eradicated, if the nullification of the impairment of the benefit is still there, so only for future compensation, compensation or retaliation would be provided. And as we've said, the appellate body is currently in crisis, and it is a big disadvantage because it results in some negative consequences for those decisions rendered by the panel. You may see that under Article 16, parties may formally notify the DSB of their decision to appeal, and then the report of the panel does not actually come into effect because it cannot be adopted before the appellate body issues the decision, and currently there is no appellate body formed within the WTO. So those decisions of panels which are appealed formally, they go into the limbo. We don't know actually what is their status. They can neither be adopted, nor could the appellate body take care of those matters. So that is a big disadvantage of the current situation, because there are decisions still rendered by panels. And what is actually the problem with the appellate body there is that the United States has been blocking the selection of the candidates for the appellate body, and their terms expired actually. So under Article 17 of the Dispute Settlement Understanding, a standing appellate body shall be established by the DSB. The appellate body shall hear appeals from panel cases. It shall be comprised of 7 persons, 3 of whom shall serve on any one case. So the minimum number of appellate body members to hear cases is 3 members. We currently don't have 3 members that do still have their term not expired. And it says that the DSB, same Article 17, the DSB shall appoint persons to serve on the appellate body for a 4-year term, and each person may be reappointed once. So that was exactly the problem that started with the reappointment of dispute settlement of the appellate body members from the United States, and it is not the recent problem actually. So here next comes the part of an article by Steve Charnovitz, a U.S. lawyer who is writing on the International Economic Law and Policy blog, and he writes down the beginning of the story. You know, currently Trump, with all his policies, is considered an evil, personal evil. I don't know, the worst leader possible, whatnot. But it is not actually the problem of Donald Trump at first instance when the US started blocking the reappointment of the appellate body members. And the problem started with the liberal icon President Obama. And President Obama in 2011 first refused to reappoint Jennifer Hillman. She was the member of the appellate body, very respected member of the appellate body, and it was reported that it was because she did not support the protectionist measures by the US government. And then in 2016, I think it was 2016, Obama administration refused to reappoint the member of the appellate body from South Korea. And it was specifically, straightforwardly stated that they are not happy with the decisions made by the appellate body, and they were claiming that the appellate body members are accountable for the views that they have endorsed. So the administration straightforwardly expressed that they don't like the decisions, they don't like to be found in violation of WTO rules, therefore they will not reappoint these members. And that was the starting point of the whole conflict, because it started then, and with Donald Trump, this policy kept further and further and further. No other members of the panel, no other members of the appellate body got reappointed. The United States claim that there is a need for reform. They are unhappy with judicial activism of the appellate body. They are unhappy with the rule of precedent as accepted by the appellate body, as if accepted by the appellate body. They do not like the situation when the members of the appellate body whose terms expired could still continue as members of the appellate body on those cases that they actually started listening to before the expiry of their terms. So there are many disappointments the United States express with respect to the appellate body. However, there is no real way out of this situation, because the appellate body cannot be reformed in any fashion that the United States is proposing. So that lasted and lasted. On the 10th of December 2019, the number of the appellate body members whose term has not expired reduced to 1. So here in the Telegraph, they say if Trump doesn't back down this week, the WTO's Dispute Resolution Court will cease to function. Well, not entirely correct. It's only the appellate body that will actually cease to function. But Trump didn't back down. So now we do not have WTO appellate body functioning because there are no appellate body members appointed. And as for the appointment of the appellate body members, consensus is required. So in that sense, it will be not an easy way out. In order to somehow resolve this matter, the EU and 15 other WTO members established an appeal arrangement, which is a temporary appeal arrangement for trade disputes. So it is called the Multi-Party Interim Appeal Arbitration Agreement. It is available on internet. You can see the details. There are many questions that are still there, but the framework is clear. It is framed under Article 25 of the DSU, arbitration. Indeed, parties can refer disputes to arbitration, and the goal is to use the mechanism that would resemble the features of the appellate review under the DSU as much as possible. You may see those countries that already joined, Australia, Brazil, Canada, China, interestingly, right? The EU, Mexico, New Zealand, Norway, Singapore, Switzerland, Uruguay. Just recently, other members joined. If only I remembered. Nicaragua clearly joined. I think Ecuador. So there are other parties joining. Russia is also considering joining this appeal arbitration agreement, arbitration arrangement. We don't yet know how it will function. It is not yet in place, but it is likely to replace the appellate body as amongst these members in their dispute. And the United States, what these guys do, US files appeal into WTO system it has broken. Reuters in December 2019, the United States on Wednesday actually filed an appeal on a dispute they did not like. It was a steel dispute with India. So what happens with the panel report? The panel report never comes into force. And what is the next step? No much chance to resolve the dispute. So if there is no multilateral, this temporary instrument available between the two members, then they could either refrain from appealing the decision of the panel, or if they appeal, then it gets into the limbo. And the last story that we need to understand: what happens if someone does not comply? What happens if by the moment retaliation is possible, the measure is not brought in compliance with the WTO rules? It is very simple. Article 22 of the DSU gives two options for reaction for non-compliance: compensation and the suspension of concessions. So to begin with, option one: if the member concerned fails to bring the measure found to be inconsistent with the covered agreement into compliance, or otherwise comply with the recommendations within a reasonable period of time, such member shall, if so required, and no later than the expiry of the reasonable period of time, enter into negotiations with any party having invoked the dispute settlement procedures with a view to develop a mutually acceptable compensation. So the first option is to find a mutually acceptable compensation that should be discussed before the expiry of the reasonable length of time, and it should be reached with any party that has invoked the dispute. There can be several complainants about one and the same measure, and therefore each of those complainants will have its own individual right for compensation. So what could this compensation be? Well, usually we treat it as a compensation in the form of additional market opening. Yes, for instance, we increase duties on one product, but we can decrease duties on other products that you need, or we could allocate you an additional tariff rate quota, though again, it may be very questionable from the MFN perspective. We could give you some other benefit. It can be anything that two parties are happy to accept. Could this be a monetary compensation? Well, technically it could be a monetary compensation. Did we have many monetary compensations following the disputes? No, because governments do not have free money from the budget just to cover some foreign decisions, international decisions, and it is even easier for them to decrease, say, import duties than to pay money out of the pocket immediately. But does it happen? Yes, it can happen. There was one case, US Section 110 of the Copyright Act. It was the only situation when the United States promised to make a lump sum payment in the amount of $3.3 million in order to compensate for the losses suffered by the EU. So can it be utilized? Yes, it can. Do such monetary compensation happen frequently? No, they don't. In most cases, compensation is not feasible, and therefore then the winning party has the right for suspension of concessions. If no satisfactory compensation has been agreed within 20 days after the date of expiry of the reasonable period of time, any party having invoked the dispute settlement procedures may request authorization from the DSB to suspend the application to the other member concerned of concessions or other obligations under the covered agreement. Importantly, such requests for authorization of suspension of concessions are decided also by reversed consensus. So whenever a member requests the authorization, it will get approved. So the losing party cannot block it as well. So what do we mean by suspension of concessions? We understand the word concessions. We heard it from the schedule of concessions. And whenever we say suspension of concessions, we mean that the winning party can stop fulfilling its own WTO obligations with respect to the losing party. Most often it happens through tariffs. So you are no longer, as a winning party, you are no longer obliged to provide to products originating from the losing party treatment as, say, according to your schedule. You can increase tariffs on their products at a higher level so that to compensate for the losses depending on the amount of the suspension of concessions permitted to you by the dispute settlement body. Those amounts of suspension of concessions can be really impressive. Just recently, again, 2019 story, US wins record 7.5 billion sanctions over EU in the WTO GATT case. That is the story we mentioned several times, Airbus, Boeing dispute on subsidies. The World Trade Organization gave President Trump the go-ahead to impose tariffs on as much as 7.5 billion worth of the European exports annually in retaliation for illegal government aid to Airbus. And then Bloomberg gives us their analysis of the record awards in sense of those tariffs which can be implemented as response to the violation. You see that 7.5 indeed is record. There was a big dispute between EU and US called US FSC, Foreign Sales Corporation, where retaliation was also impressive. But otherwise, figures are not that big, and you saw that, well, compensation, say, even in the copyright dispute was only $3.3 million. That is a very small compensation according to the standards, but still here we count more on even billions, as you may see in the Airbus case. But usually it is less. It is less. You may see even in those record numbers of previous cases, it is less than $1 billion. But records also happen. So the United States is permitted to increase tariffs on the European products at the amount of $7.5 billion a year. That is a lot. So each and every European product entering the territory of the US may be subject to a higher import duty, import tariff. And once the United States collects this sum of 7.5 million, it has to stop applying the retaliation mechanism. It has to stop suspension of concessions, and the next year they will start it anew to collect this sum. So there is no punishment that is provided for in the schedule. The goal of suspension of concessions is to compensate for the losses and to stimulate compliance. And clearly, the most attractive way to impose tariffs is to hit the most sensitive products from the losing party. So when choosing those products which will be subject to higher taxes, countries try to be as aggressive as possible. They choose the, if it's the EU context, for instance, the EU is violating, EU doesn't bring measures in compliance, and the EU does it regularly. What happens is that usually sanctions target agricultural products, wine, cheese, those products which are, in addition to being just matters of significant state support, but are also subject of, well, sort of national pride, EU pride. So clearly the goal is to hit those producers which have more bargaining leverage with their governments, that could run to the European Commission and request to comply with the decision. So how do we determine those products? Are there any rules, and how do generally countries determine those products that will be subject to suspension of concessions? In considering what concessions or other obligations to suspend, the complaining party shall apply the following principles and procedures. First, the general principle is that the complaining party should first seek to suspend concessions or other obligations with respect to the same sector in which the violation was established. So if we say that the violation was with respect to import tariffs on cars, then the general principle is that compensation should be in cars, not the compensation, the suspension of concessions should be in cars. So as a general rule, we should try to seek suspend concessions in the same sector. If the party considers that it is not practicable or effective to suspend concessions with respect to the same sector, it may be the case that this product is not being sent in this opposite direction, for instance. So then a party may seek to suspend concessions or other obligations in other sectors under the same agreement. So if the violation was, say, with respect to cars, but we can retaliate, we can suspend concessions with respect to agricultural products, for instance. And then, if the party considers that it is not practicable or effective to suspend concessions or other obligations with respect to other sectors under the same agreement, and that the circumstances are serious enough, it will require some clarification, clearly, it may seek to suspend concessions or other obligations under another covered agreement. So if it's a violation of the GATT, you can suspend concessions with respect to services or vice versa. So that is the situation when you can start doing so-called cross-retaliation in case you understand that you could not effectively suspend concessions with respect to the same agreement. It is most important for smaller economies that cannot that easily, hit the producers of the US, because they may not even import as many, so that to compensate for the losses, so that to reach this compensation level as permitted by the DSB, as authorized by the DSB. So actually, you can cross-retaliate in other sectors. There has been a very interesting case with respect to the so-called carousel suspension of concessions. That is the provision of the US law, according to which the list of products subject to retaliation has to regularly change every, well, at least every 180 days. So why is it done? In order to increase pressure on the government of the foreign party. So today we would apply additional tariffs on steel, and steel producers go to the European Commission. Tomorrow we will apply additional tariffs on wine, and wine producers will go to the European Commission. The day after tomorrow, we will apply tariffs on lipstick, and lipstick producers will go to the European Commission. All of them will be pushing for compliance. Please comply, we don't want to suffer. On the other hand, it is disadvantageous to the consumers as well, because consumers don't know what would be the price for the product coming to their territory. Tariffs can change. Product chains can be broken because of higher tariffs, and therefore the United States also threatens to use this carousel suspension of concessions, but they actually didn't yet apply it. Why is it called carousel? I guess you understand. It's like a carousel. You jump in, take a ride, jump off. just like those products which regularly change and the list gets revised, revised, and revised. There were two cases when there was a high risk of the US applying this provision of law, and it was threatening the carousel suspension of concessions, EC bananas and EC beef, when EC refused to comply. And still they never did it. They never did it. The EU was saying it is contrary to WTO rules, is unpredictable, what is questionable, but that is the position. But as I said, mostly it is harmful for the domestic distributors. They don't know whether they will have the supply or not, whether it falls under the lower tariff or the higher tariff. So as of now, carousel suspension of concessions is not applied. But it may be utilized in future, and it may be a dangerous game if everyone starts doing it. And to conclude, there is one interesting story that relates to suspension of concessions, which is important to understand. We have mentioned the case of US gambling. You recall it was the story of US prohibiting online gambling, online casinos, and the complainant in that case was a tiny territory. I will show you this territory on the map. I doubt you recognize what country was the complainant in that case. So you see the Caribbean Sea, and then the small territory is Antigua and Barbuda. These are the two islands which were actually the complainant in this matter, and they were in the long run supporting businesses of the US citizen who had all his servers with online casinos located there. So he funded the case. In the long run, it's a dispute of US against the US citizen within the WTO. But formally, it was a dispute that was raised by Antigua and Barbuda, and Antigua and Barbuda indeed was very dependent on their businesses because a lot of people worked in the field of this online casino management, and indeed they had a big decline in taxation following this prohibition of online casinos. So it is not only the US citizen that was disappointed, it's the government of Antigua and Barbuda as well. And the government of Antigua and Barbuda managed to win the case. They managed to win the case under the GATT agreement, and they managed to demonstrate that the US acted in violation. Antigua and Barbuda even managed to get some permission to retaliate. But how would Antigua and Barbuda retaliate against the United States? They would increase tariffs, right? Or they would somehow restrict other services. Well, the US is hegemon in the region. They produce most of the services. And if Antigua and Barbuda starts restricting the US services, they themselves would not have the necessary services available. So increase import duties on US tariffs. Well, you could do that potentially, but what happens if you increase duties? The price of products in your domestic economy of these foreign products will go up. If you don't have a lot of domestic production, like Antigua doesn't have a lot of domestic production, then who will be unhappy with this retaliation? Who will be unhappy with this suspension of concessions? Your own domestic consumers. They will arrive to your building and say, why are you increasing prices? Why is everything now more expensive? And you will keep explaining them about the decision, retaliation. No one will be happy. So suspension of concessions and retaliation is generally a costly exercise in most cases because it still disturbs your domestic consumers. Increasing tariffs always increases domestic prices. So your domestic consumers will now suffer because of the increased tariffs. And the United States was absolutely convinced that Antigua and Barbuda shall never retaliate just because they have no capacity to retaliate. They are so dependent on the production and generally import side on the United States, that it would be a huge disadvantage for Antigua and Barbuda to increase duties on products or to restrict US services just because they will hit themselves. But Antigua was very inventive in a way, though this scenario has been discussed in literature. What they actually requested the dispute settlement body to do was to permit the suspension of concessions with respect to the TRIPS agreement, intellectual property. We completely forgot that in addition to goods and services, there is also intellectual property aspect, TRIPS agreement. And you can also suspend your obligations with respect to the TRIPS agreement. So you can disregard US copyright, you can disregard US patents, you can disregard US trademarks, and you can do all other bad things which will be very disturbing to the US. And here is what actually Antigua and Barbuda did. Caribbean nation gets an international go-ahead to break US copyright laws. So what here is said is that Antigua and Barbuda has the right to offer downloads of American intellectual property, Hollywood films, TV shows, pop songs, and not pay a penny to the United States and to the owners of the intellectual property. And the WTO therefore permitted this legal piracy, as we could call it. So those guys within the WTO who are the owners of intellectual property can be very unhappy with the fact that their government does not bring their policies in compliance with the WTO rules, because they can suffer. I did not manage to find this website that Antigua and Barbuda could establish to violate the rules, to punish the USA for the violation, and to collect money not paying anything to the US. So I didn't just manage to find it, but I guess it may be there online or elsewhere. The US was very unhappy with this fact, and therefore retaliation for smaller nations can be this cross-border, cross-sector retaliation, cross-retaliation, just because sometimes for smaller economies, it is very problematic to retaliate in respect of goods or services, because they simply don't have enough volumes in their economy, and their consumers will be very unhappy. So that could also happen. Legal piracy is is sometimes even internationally permitted. So, cut a long story short, where are we with the dispute settlement system? Is it still valid? Is it still necessary? Absolutely so. Valid and necessary, and you may see how many disputes there are annually, and you can see that the number of the average monthly number of disputes is only growing in the last years. So the dispute settlement system remains relevant. With the crisis of the appellate body, yes, it can face certain troubles, but I doubt that this jewel, this crown, will not be somehow this way or the other saved by the WTO members who wish to maintain it. Yes, the United States is currently restricting the functioning of the system, and they insist on the need to reform it. Maybe it gets reformed in a way. Maybe this temporary appeal arrangement will become very effective and very much utilized, and it will follow the principles and case law of the appellate body. We'll see. However, definitely the dispute settlement system has been very successful, extremely successful as compared to many other international dispute settlement mechanisms. And just some basic statistics, as of today we have around 600 disputes. With the other figures, they are maybe a little older, so they may be higher now. It is these are the figures of maybe 2018, but you may see that a lot of members have initiated at least a dispute. Every third member to the WTO, 60 members have been respondents, 88 have participated as third parties, and overall 109 have been active in dispute settlement as a party or a third party. What is a lot given that we have around 160 members, so the mechanism is very much in demand among the members. And as for the compliance panels have only been established in 49, 50 disputes, and it is about only 20%. So in all other cases, the parties either somehow managed to agree on the settlement, or the compliance has been performed. And then as for suspension of concessions, it has been there in 16 disputes only. So those examples of clear non-compliance, of clear disregard of the result of the dispute settlement system are very rare. In national systems, it happens much more often. The compliance rates are much lower, and the rates for some enforcement are much higher. So that is it with respect to the system of the dispute settlement. Now you know what happens if someone does not comply with the WTO rules. Now you know what happens if governments do not fulfill their obligations, and that indeed they can be subject to very painful sanctions, which they greatly don't like. Even smaller nations can be inventive and introduce certain mechanisms so that to hit the huge hegemons which consider to be unavailable for any revenge from those smaller territories. And the system of the settlement of disputes indeed is the crown, is the jewel in the crown of the WTO, and I hope that it will stand out through the turbulence, and the system will continue function this way or the other, because it is essential for the functioning of international economic law.